all the public representatives in the Parliament of Zimbabwe are now officially facing a constitutional court challenge. They are supposed to respond to the affidavits served to them within a period of 10 days. Failure to do so, a judgment may be made without them also having to present the side of their story on the matter, and they are accused of seeking to extend their own term of office with 2 additional years. Remember also, on the other hand, Emerson Tambutso Mnangagwa is facing also a constitutional court challenge, but the attitude of the Mnangagwa faction shows that they are stubborn. They are fighting also so hard against the retired General Chiwenga faction, because we've heard that the security apparatus are already hunting down people who have actually taken these members of parliament to the constitutional court. Greetings and welcome to your lovely channel, the Hlonipani Global News. If you are watching us for the very first time, please do remember to press the red or black subscribe button, so that next time when we beam live, you become the very first one to watch us. I think there is an account which is written Zwamai Tanga Mohondo. It actually postulates this in a clear manner, and I share some of the sentiments. It says, of Constitutional Amendment Bill number 3, I want to walk you through something, not the passive, empty commentary of the propagandist, not the soothing lies about a lawful process sailing through a willing parliament, the live wire situation, the strategic reality beneath the headlines, the war of attrition that is unfolding while the cabal's mouthpieces tell you to relax and let democracy take its course. Ignore them, they are lying to you. What is happening is not normal legislative business. It is a legal encirclement, a race against the clock, and a constitutional siege. Let me lay it out. Part 1. The encirclement. All 210 members of the National Assembly have been served with constitutional court applications by voters from their own constituencies. Let that number circle, 210, every single MP. This is unprecedented in the history of this republic. Parliament is no longer merely debating Constitutional Amendment Bill 3. Parliament is the subject of a mass constitutional complaint by the people it claims to represent. The chamber has become the clock. Each applicant is filed under Section 85 of the Constitution. The citizens get to the court. No personal injury is required, no special standing, only an allegation that a fundamental right has been violated. The right at issue here is the right to democratic participation under Section 67. The voter is saying, my MP is about to vote for an amendment that extends their own term and the president's term without my consent, in defiance of Section 3287. That violates the Constitution, and by violating the Constitution, it violates my right to be governed under a constitutional order. The procedure in Rule 26.2 of the Constitutional Court Rules 2025, the MP has 10 days to file a notice of opposition. If they do not, if they ignore the papers, if they take the bribes and to stay quiet, the application proceeds unopposed. The court may grant the order without hearing them, and that order will declare that the MP's participation in CAB.3 is unconstitutional. Now understand the consequences. Once that order exists, voting for CAB.3 is no longer a political choice. It is contempt of court. It is a personal legal catastrophe addressed in a parliamentary vote. The MP who defaults cannot simply proceed as though nothing has happened. They are legally barred. And if they vote anywhere, they face the full weight of a constitutional court contempt finding. Part 2, attrition war. The strategic genius of this intervention is multiplication. The cabal's legal machinery, formidable as it is, funded as it is, lawyered as it is, was built to fight one battle, a single challenge in the Concord. Perhaps 2 or 3, the full resources of the state legal apparatus deployed to defeat them. And that is what the cabal prepared for. It was not built to fight 210 simultaneous battles. It was not built to file 210 opposing affidavits within 10 days. Each one tailored to a specific constituency, a specific applicant, a specific respondent MP. It was not built to coordinate 210 individual legal defenses while simultaneously whipping the same MPs through a parliamentary vote, managing a national propaganda campaign, and keeping the provincial chairmen in their new vehicles. The strategy overwhelms by numbers. It dissolves the collective anonymity that the whip replies on into individual legal exposure. Every MP must now decide personally whether to oppose, default, or break ranks. The cabal cannot decide for them. It cannot file a single affidavit for all 210. It cannot consolidate the cases without the consent of every applicant, which will not be forthcoming. The machine is drowning in process, and that is precisely the point. Part 3, the liability. Let us now speak plainly about what each MP faces. They face 3 options, and none of them is safe. Oppose, file a notice of opposition, enter an affidavit under oath, defend the constitutionality of extending your own term without the people's consent. Every word becomes a public document. Every argument is tested, scrutinized, and entered into the permanent record of the Republic. The affidavit follows you into the next election. It follows you into history. It follows you into the reckoning. Default, do nothing, let the 10 days lapse, the application proceed unopposed, an order is granted. You are now legally barred from voting for CAB.3. If you vote anyway, you commit contempt. The bribe of US 50,000 will not cover the cost of a contempt finding. The whip will protect you from a court order. The president's, whoever wins, will not save you from the judiciary. Break ranks, announce that you will not vote for CAB.3 or that you will vote against it. The application against you becomes moot. The legal jeopardy lifts. But the political jeopardy of crossing the cabal descends. You might weigh the whip against the writ, the bribe against the bench, and you must do it alone. There is no collective shield. The anonymity of the caucus is dead. Every MP stands alone, named, served, and washed by the constituents who took them to court. Part 4, racing the clock. Now you understand why Ziambi moved his motion today. CAB.3 entered its second reading, and immediately the leader of the House requested that all other government business be suspended so that the House could debate CAB.3 into the night. An opposition legislator challenged this, citing personal security and the dangers of moving through the city after dark. The challenge was procedurally valid but strategically insufficient. The motion will likely pass. The night sitting will proceed. Why? Because the cabal is racing against the 10-day clock. The applications were served around 2 to 3 June. The opposition window closes around 12 to 13 June. Default orders could begin issuing shortly thereafter. If the parliamentary votes takes place after those orders are granted. Every MP subject to an order who votes yes commits contempt. The 2/3 majority becomes mathematically impossible if even a modest number of MPs are legally barred. The cabal must complete the vote before the default crystallizes. Speed is the only advantage left. The legal arguments are weak. The political legitimacy is evaporating. The generals have warned. The voters have sued. But speed can still win if the vote is gravelled through before the court process catches up. The night debate is not deliberation, it is exhaustion. It is a tactic designed to grind down opposition, to push the vote through when the nation is asleep, when the cameras are off, when the people cannot watch their representatives sell them out in real time. The suspension of all other government business is a confession. It tells us that nothing else matters, not the economy, not the health system, not the currency, except the extension of one man's term. The nation is being held hostage so that Mnangagwa can be made a tenant beyond his lease. Part 5, the next move, the interdict. The cabal is sprinting, but a sprint can be stopped. And the law provides the mechanism. The correct strategic response to a night sitting designed to preempt the judicial process is an urgent chamber application for an interim interdict. This is not speculation. It is the remedy to the Constitution. It is the remedy the Constitution provides when a litigant seeks to protect the subject matter of pending litigation from being destroyed by one party's haste. The application would be brought under Section 85, supported by a certificate of agency. It will be filed with the registrar of the Constitutional Court, even after hours if necessary. The rules provides for a duty judge to receive urgent filings at any time. The papers would be placed before that judge, even at midnight, and the judge would issue an order halting the parliamentary process pending the determination of the 210 applications or pending the delivery of judgment in the main section 3287 challenge. The grounds would be precisely what Ziambi has just done. Parliament is attempting to complete the vote under cover of night, specifically to defeat the court process. The 210 applications would be rendered meaningless if the vote is concluded before the 10-day window closes. The rule of law itself is under assault. A judge who receives such an application at 1 a.m. and who reads the general's warning and who sees the president, whoever wins, and who understands that the chamber is being held overnight to outrun justice, that judge has the power to stop the clock, and the Constitution expects them to use it. The court is always open for the protection of fundamental rights. The agency of the night is not a shield for constitutional violation. An interdict granted at 2 a.m. is as binding as one granted at noon, and if it lands while the MPs are mid-debate, the entire spectacle collapses. The speaker, the speaker must halt the proceedings. The vote cannot proceed. The cabal's timetable is shattered. Conclusion: the plot is simmering. This is not the time to relax. The overwhelming applications have changed the legal landscape. Apologies. Ziambi's night motion has confirmed the cabal's desperation. The 10-day clock is ticking. The Concord is deliberating. The generals are watching, and the archive is recording every minute. The people have entered the courtroom. The law is in motion, and those who think they can outrun justice by debating into the dark have forgotten that the Constitution does not sleep. if you listened to this, it tells you that the other faction appears to be in charge of what they are doing. Thank you very much for watching us. If you are watching us for the very